All right. Top of the morning, top of the evening, top of the night, whatever time zone you are on. We are live. Hello, everybody. Happy Black History Month. Right. Hopefully, everybody's doing the best that they can in the situation that they are in. With that being said, I want to go ahead and have our moment of silence for all hosts of people who have transitioned this year and lost their lives. Okay, now I'm going to check the sound in the background. It has been good the last few days, even though I have not been live on here. Check this out. Share my feed. Make sure I can see myself. Hear myself, I should say. Hear myself, I should say. Okay. Did she just post? Hear myself, I should say. Okay. Yeah. All right. Okay. So now that I can hear myself in the background again, hello everybody. We finished our moment of silence. Happy Black History Month. It's not over. Now let me take a moment and do this real right here. Now, I've gotten comments before about the particular jewelry that I wear at times, and this right here, since it is Black History Month, is customized by a Black designer, specifically for my ear. So again, since it is Black History Month, and people always say support this, support that, you'll see me often in customized pieces from my I'm calling this person my designer. And so you want to look like this, you don't get introduced to my designer, and you better have some money. And I'm talking about a couple of hundred off the gate, depending on what you want. It'll be up into the thousands. Now, and that's my Black History plug. Having said that, let me do the share on this music, because we're going to get to this tonight. Hey to everybody. Let me say hey in the chat. Hello, everybody. Hello. All right. Again, I did my plug for my designer for Black History Month. Yeah. Want this, you got to drop some cash. No. Let me do the share on this music, and we're going to get off into this. This is what I want to share. All right, let's get to this music. Why didn't we work like that? Let's go.
Hush not, child, and don't cry.
I need more bass on this.
Your folks might understand you by and by. Just move on up toward your destination. Though you may find from time to time complication. Bite your lip and take the trip. Though there may be wet road ahead and you cannot slip, just move on up for peace to find. only one kind.
Again, happy Black History
So
Month,
hush now,
everybody.
child,
I am in my
and
customized
don't cry.
earrings
Your
and
folks might
neck
understand
attire
by and
created
by.
by my Black
Move
designer.
on up
Black
and keep
History
on
Month.
wishing.
You'll see me in customized pieces
Remember your dream is your
all
own
throughout the
skin.
year.
So keep on pushing.
But remember, celebrate Black History Month. Invest in Black businesses.
Take nothing less than the supreme best. Do not obey, you must be forsake, but you can pass the test. Just move on up to a greater day. With just a little faith, if you put your mind to it, you can surely do it. Just move on up. Move on up. But move on up. Watch out, but just move on up. But move on up. Move on up.
Now, that's the extended version of Curtis Mayfield, but we're going to stop there because I have got to get to these deadbeat attorneys tonight. I've got to get to these rotten and corrupt judges, police, system, and the like. Again, happy Black History Month, everyone. Make sure that you support Black business every day of the year. Again, when you see me in certain pieces that you've seen nowhere else, it is because my Black designer have created and designed them. And I wear jewelry all the time that you probably see nowhere else. And just know when you see me in certain pieces, it's designed by a Black designer. And you want pieces like these, you're going to have to pay that cash. But support Black business. We support other businesses, but support Black business. Okay. Now, having said that, let's get to this corruption. Let's get, before I even get to the PowerPoint, I would just like to say we need to be careful of the attorneys who litigate these cases. We need to be mindful of the judges that preside over these cases. We already know we need to stay actively engaged. And I'm borrowing a word from my family member, one of my family members tonight. Now, for those of you attorneys and judges who went to a university and you have a Juris Doctorate degree, that means your Juris Doctorate is good for nothing because you're not competent, you're ineffective, and you don't help anybody but your own pockets. Okay. For those of you who have these jurisdumjic degrees, degrees, this is for you. This is for you. When I have rotten and corrupt in the title, this is for you all. Okay. For all of you who don't represent people, which equals to zero justice. Yeah, that's right. This is for you. Let me go ahead and get started. And so I will be using examples tonight. Disclaimer: in accordance to the Copyright Act of the United States of America, sections 106, 107, and the others, fair use. I have a right to use the videos, images, pictures, the like, so on and so forth. This information is now a matter of public record in accordance with the Copyright Act and Freedom of Information Act of the United States of America. Yeah. I did that too soon. Now, let's get to this share. Again, to you attorney and judges who have jurisdumjic degrees, and that's the term I borrowed from a family member. You have netted people no good. Okay. And you don't sit up there for justice. You sitting up there to be rotten to the core. And you sitting up there to be corrupt. And you sitting up there with your unethicals, non-integral, having backsides. And you need to be disbarred. Many of them need to be disbarred. I said it. That's right. And the system over here, we already know facets of the system in the United States is corrupt. We already know that. Okay. Is everybody participating in something that's unethical or non-integral and lack integrity? No. Do judges, police officers, and others participate in things like that? Yes. Are we aware of that? Yes. All right. So let me blow this up. And again, it's Black History Month. Happy Black History Month, everyone. We'll continue Black. I haven't stopped. Again, graphic parental consent. Viewers' discretion is advised. This is not for minors. All right. Before I get to these rotten and corrupt judges, attorneys, and the like, and why is my S off on that one? Did I not put an S on the rest of them? Let me see something really quick. Okay.
The prosecution and defense have now rested in the federal hate crimes trial for 3 men convicted of killing Ahmaud Arbery. Several witnesses.
This is the Ahmaud Arbery.
Travis McMichael and his father Greg. Ripley has more on key developments from court. A warning: some of you may find the language used disturbing.
Marcus Arbery Sr. made the slow walk to the courthouse Friday, bracing for more testimony about the men standing trial for federal hate crimes and his son Ahmaud Arbery's death. A weapons expert with the GBI determined Travis McMichael's shotgun was nearly touching Arbery when Travis fired it. After seeing the weapon that took his son's life, Marcus left the courtroom. The prosecution spoke to a neighbor of the McMichaels. The neighbor said Greg McMichael rented out houses. The neighbor says he once called a renter a big fat black woman and referred to her as the walrus. The neighbor added that McMichael said he cut off the woman's air conditioning during the summer, saying, quote, "You should have seen how fast her big black came with the rent check."
It was just a damn melee.
Stop him out of the truck running at us.
I told him, stop, 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 till he hit me.
Travis McMichael's former boss later testified that Travis called him the day he shot Arbery, but when cell phone video that William Roddy Bryan recorded was released in May, McMichael's boss said he was shocked and upset to learn Travis lied to him about claiming self-defense.
All that was lies. Ahmaud hadn't stole anything, but what he did was he called his employer to try to cover his own behind.
One of Travis McMichael's former coworkers who once dated a black man said Travis told her, quote, once you go black, you're in a wheelchair. She said Travis called her a lover more than once. She says she didn't report the comments out of fear because Travis was her supervisor. 11 Alive legal analyst Paige Pate says the prosecution presented ample evidence for the jury to consider.
So if you have defendants who are publicly, at least within their group, their friends, their neighbors, their coworkers, expressing racial hatred in those conversations, then it's not a long jump to them committing a crime motivated by race.
Both the prosecution and the defense will present closing arguments Monday. After that, the jury will deliberate to come up with a verdict. You can read up on the charges each defendant faces. Just head to 11alive.com. And Wednesday will mark 2 years since Ahmaud Arbery was murdered. And Arbery's mother, Wanda Cooper Jones, plans to remember him at the National Center for Civil and Human Rights next week. Lawmakers recently passed a resolution to make February 23rd Ahmaud Arbery Day.
Okay, so that's this Wednesday. But this is also in my example for rotten and corrupt judges, attorneys, and the like. And it should be an S, attorneys and the like, plural, more than one. So the example of Ahmaud Arbery, and I'm not talking about the judge who presided over the case. I'm talking about the prosecutor, Ms. Jackson, who no longer operates at this present moment in Georgia as a prosecutor, sitting on information. So when we talk about these rotten and corrupt judges, attorneys, system, and the like, I want you to think about the problem. What's the problem? I want you to think about purpose. I want you to think about a perspective. I want you to think about paradigm, and I want you to think about the price. Again, I want you to think about problem, purpose, paradigm, price, and perspective. Again, problem, purpose, perspective, paradigm, and the price. I'll say it again. When we're looking at these rotten and corrupt judges, attorneys, systems, and the like, systems, more than one, and the like, over here in the United States, when we're talking about deadbeats versus the skillful, master swords, men and women of the law. I want you to think about problem, and it also includes police. Come on, somebody. We already know the police is included in this. When you talk about being rotten and corrupt, am I saying all? No. Am I saying some? Yes. Am I saying that it happened? Yes. I want you to think about the problem. I want you to think about purpose. I want you to think about perspective. I want you to think about paradigm. I want you to think about price from different standpoints. The problem. What is the problem here with these rotten and corrupt judges? It is their what? Perspective. That's their outlook. What becomes their problem when they preside over these cases or take these cases? What's their problem? Okay. What's the problem that's leading up to zero justice when they preside over these cases, or when they take a case, when an attorney takes a case to litigate in the court? Or to go to a trial? What is the problem? It is what? Their perspective. That's their outlook, the way that they're viewing a thing. What's the paradigm? That's set pattern, a model. What's the paradigm? What's the paradigm? What's the pattern that's been laid out and the things that they are modeling out before others? Or the thing that has been modeled out before them? That's the pattern here. What is the pattern here? And when we talk about paradigm and pattern, we can also look at paradigm from their perspective. what paradigm, what pattern model have they portrayed and laid out for other people? What does their track record show? What is in their, what's the paradigm? What's the pattern that's set? It's the pattern that's set. What's the model? What is being modeled out here? And price. What is this costing the person that needs the justice? What have they given up? And what is it costing the judge? What is it costing these attorneys? What is it costing the officers? What's the cost to the family members? All family members involved on both sides. And we talk about purpose. The purpose, the reason. What's the reason for this? What's the reason? What's being for this? What's the meaning of it? What is the purpose? What's the intent? What's the purpose behind all of this happening? So when we talk about rotten, corrupt judges, attorneys, and the like, think about it. The problem, purpose, perspective, paradigm, and price. Because that's always involved. Always involved. Always. Now, the first example was the Ahmaud Arbery. Again, Miss Jackson, who set herself on this case and was suppressing evidence. She wasn't getting ready to bring any charges against Ahmaud Arbery murderers. She was going to bring no charges. That's the first example. Now, let me move on to second example involving police.
Now on 10, officers from the Florida Department of Corrections have been placed on administrative leave following the death of a Miami-Dade inmate. And we've learned one of those officers has resigned. We're told the inmate died during transfer, but the details surrounding the death are still unclear. The FDLE is now assisting in the investigation.
Okay, let me play that back again because she cut her own self off. The news cut her off at the end.
Now on 10, officers from the Florida Department of Corrections have been placed on administrative leave following the death of a Miami-Dade inmate. And we've learned one of those officers has resigned. We're told the inmate died during transfer, but the details surrounding the death are still unclear. The FDLE is now assisting in the investigation.
Insisting in the investigation. So for this example, remember, what did I say we're talking about? To think about problem, purpose, paradigm, price, perspective. 10 officers placed on administrative leave. That means they still being paid off the taxpayers' money in that state. Death in custody. Another citizen, U.S. citizen in custody of police, and they end up dead. Christina Nance from Alabama ended up dead. Was found in a police van in a police parking lot, according to them. Okay. Sandra Bland ended up dead. The other lady, and how could I forget her name? Also in Kentucky. How did I pronounce her name? That ended up dead. Okay, the one that was poisoned. According to the autopsy that was conducted. Police custody that ended up dead. This list can go on and on. Freddie Gray that ended up police custody dead. Man, we would really have to keep running names down on this. Mr. Green, Louisiana, who ended up dead. We would have to run a host of names. And so when I'm talking about rotten in corruption, because you have judges that will preside over these cases, You have attorneys who will show up to be for the defendant or the plaintiffs. Okay. You have a system in place. What's the purpose of the system? What's the problem with the system? What's the perspective of the system? What's the paradigm? What's the model or the pattern that the system has? And what's the price that's being paid? Okay. We know we got rotten police officers. Did I say all? I said no. I said we know we have rotten police officers. That's what I said. We're not going to act green or naive. We know better. Okay. We know we have rotten facets and aspects of the system over here. We're not going to act green and naive. We know better. We know better. And we know we get deadbeat attorneys on cases. Okay. We know we can have a rotten, deadbeat, trifling judges presiding over cases. Oh, I said it. Let me pull that back. We know we can have rotten, deadbeat, trifling judges presiding over cases. No ethics, no integrity, who should not be even licensed to practice. Okay. Who should be impeached. We know we got federal judges who should be impeached. And we got other judges who should be disbarred, as well as attorneys. And I'm talking about defense attorneys, and prosecutors. All the way around. Including all, in terms of what type of attorney they are, or what type of judge they are. Excluding none. Now, are they all corrupt? No, I said I'm excluding none in terms of talking about the type of judge and attorney that they are. It could be a state, at the state level in terms of being a judge. You could be at the federal level in terms of being a judge, you know, whatever. Whatever. So that's another example. The first example we looked at was the death of a mod operator. Okay, mod operator. All right. The prosecutor who originally should have brought the charges a long time ago. And let me not forget Jason Van Dyke while we're here. He did less than 5 years for shooting Laquan McDowell in Chicago, Illinois, over 15 times, 16 times. And they suppressed that evidence for over a year. Jason Van Dyke was released this month for murder. He's a murderer. He was a cop who murdered a 17-year-old African-American male and lied about it. They lied about it. So think about it. Again, rotten and corrupt judges, attorneys, cops, systems, and the like. What is the price that's being paid? What's the paradigm? What's the perspective? What's the purpose? And what is the problem? Because it's a problem. We can look at, when we're looking at these particular items or words that I've said, or meaning of words, or however you want to deem it in your mind. When we're looking at the problem, I want you to flip it. I want you to flip it. I want you to be multifaceted in terms of using this word. I want you to look at the words that I'm using in many different ways. Well, I want you to think about the words from many different perspectives. Think about the various definitions for problem. Okay. Problem is an issue. Okay. So we don't just look at the problem. How do we solve the problem? Who is the problem? I want you to think about it this way. When you're looking at purpose, problem, perspective, paradigm, and price, I want you to think about the who, the what, the when, the where, to what extent, and what degree, and how when you're looking at the problem. I want you to do the same thing for purpose. I want you to do the same thing for perspective, and I want you to do the same thing for paradigm and price. Who, what, when, where, how, to what extent, which one, what kind, what types. Okay? What purpose? Who, how, when, where, what kind, to what extent. Perspective, paradigm, price. I want you to think about all of this as we are going through these different examples. First with Ahmaud, now we're looking at these police officers full of what? Corruption. 10 on leave, administrative leave. Person ended up in their custody, what? Dead. How? How does it happen? To what extent does it happen? What is the problem when there's surveillance available? What is the problem? What is the issue? What's the paradigm? What's the pattern that's in the system that's set up? What's the model? What price is being paid? How caustic are these things that's equaling to zero justice? When we talk about rotten and corrupt, and hear me good, I said rotten, downright rotten to the core, rotten and corrupt. I got the and there, if you want to look at words in a different light. So, rotten and corrupt. In addition to being rotten, also corrupt. Judges, attorneys, and the like. And I'm saying it this way because I'm going somewhere with this. Let's keep moving. Let's get to the next one. Let's get to the next example. You know who I'm coming to. Kim Porter, another officer and a judge. Officer that I call Officer Taser. Okay, what did we say we're looking at? Problem, purpose, perspective, paradigm, and price. We're flipping the words. We're looking at words in a different light. Words in a different light. Multifaceted. Many different ways, many different things. Let's go.
Ms. Potter, will you please rise? Given all these considerations and having carefully considered the comments of the family and of both Dante Wright and the comments of Kimberly Potter, as well as the arguments of counsel, it is the sentence and judgment of this court that you shall be committed to the custody of the Commissioner of Corrections for a period of 24 months. You shall serve 2/3 of that time, or 16 months in prison, and 1/3 on supervised release, assuming no disciplinary offenses or conditional release violations. You have credit for 58 days already served. Restitution will be reserved. There'll be a fine of $1,000 and a surcharge of $78 to be taken out of prison wages or due within 180 days. You must provide a DNA sample. You may not use or possess any firearms, ammunition, or explosives. You have the right to appeal the conviction and sentence, If you are unable to pay the cost of an appeal, you may apply for leave to appeal at state expense by contacting the state public defender.
Pause for a minute before we get to the judge crying on the stand. Not on the stand, but crying from the bench, from her, where she's presiding, where she's sitting. Let's look at the problem. Let's look at the purpose. Okay, what is the judge's purpose? Why are judges even allowed in courtrooms in America? What's the original intent behind having a judge? What's the original intent? What's the purpose of even having a judge? What is the problem here? Judge, it's a problem, Judge. It's a problem. It's a problem I have with this judge right here. What is her perspective? What is the perspective overall? Okay. Not only what is the perspective overall, what is her perspective? What is the officer's perspective? Excuse me, hold on for me to pump the brakes. The problem I hear right off the back is a sentencing problem. Because I said we was looking at problem from different perspectives, different ways. Okay. We also looking at perspective. That's how you view things, how you see things. I said we're looking at the paradigm. Okay. That's a model. That's a pattern that's been set. So we're looking at a price that's being paid. We're looking at the different ways we can look at a price and break that down too. We're looking at the purpose. Excuse me, Judge. What is the purpose of a judge in the United States? Why is she even here presiding over this case? It's the problem that led up to the officer being here in the first place. It's the problem. What was the perspective of this officer that got her here in the first place? What was the problem? What is her perspective? What was her perspective that got her here? What paradigms were set before her? What models and patterns was she watching to lead her to the sentencing, to kill somebody? And then you got a judge who's getting ready to sit up and cry. Anyway, and the price that's paid for this is precious life lost. Another life lost. Okay? Another person is dead, and you cannot bring them back. So you have what? More families being what? Traumatized, pain, suffering, traumatic life experiences. What you had outside factors, outside environmental factors that impacted their life. The outside environmental factor or thing that impacted their life that they didn't plan for was for Deontay to be murdered and shot by a cop who stood there and said, taser, taser, when she had a gun. Okay. Let me again, we are the problem, purpose, perspective, paradigm, and price. Think about all of that from different aspects as you continue to listen to another example of rotten, corrupt judges, attorneys, police systems, and the like.
You may be seated, Ms. Potter. I'd like to make a few parting comments. I recognize there will be those who disagree with the sentence. That I granted a significant downward departure does not in any way diminish Daunte Wright's life. His life mattered. And to those who disagree and feel a longer prison sentence is appropriate, as difficult as it may be, please try to empathize with Ms. Potter's situation. As President Barack Obama once said,
"Oh, no, you didn't."
Learning to stand in somebody else's shoes, to see through their eyes.
Wait a minute.
That's how peace begins. And it's up.
Pause for a minute. By the way, I've already seen this particular footage, okay? Sometimes I come on and I haven't seen the footage, but this I've already seen. But every time I want to say, oh, no, you didn't, Judge. No, you didn't. That's a problem. That's a problem. You're going to try to quote President Barack Obama. Stop. Stop. It's a problem. I'm looking at a problem here. I'm looking at the purpose of her saying that. I'm looking at the perspective. I'm looking at the paradigm. And I'm looking at the price. Because from my perspective, she's double talking. Double talk. When you say, listen to the setup. We also have to consider, it's not to minimize the lives of Deontay. We also have to consider looking at it from the police eyes. What? They can legally kill and get away with it. That's a problem. And that's the perspective that I'm looking at. She just got away with murder. That's what I'm looking at, because 24 months, let me use my best slangonomics, ain't no time. You got people who didn't murder anybody, who are innocent, who served 30, 40, 50, 60 years, who did nothing. But what? It was the what? Corrupt and rotten system that led to them being there. And you mean to tell me you want to sit up and give these officers immunity, which is another problem. And then you want to look at it through her eyes? No. See, the problem is officers can kill and get away. You talking about how to kill and get away with murder? Over here in America, for the people who aren't Americans, if you want to kill and get away with murder over here in America, the field that you're going to want to be in is law enforcement. That's the job you're going to want to have. And that's my perspective. And I can back it up with facts. All I got to do is run the cases. I can run a bunch of cases. For the next couple of years, we can just run cases. We'll go all the way back to the inception of the United States and walking on up to 2022. We'll go from state to state. We'll go from city to city. We'll go county by county. And then I will have proven my case, because I already know I can substantiate the claim. That's a problem. That's a problem. That's a problem.
To you to make that happen. Empathy is a quality of character that can change the world. Officer Kimberly Potter was trying to do the right thing.
What?
Of all the jobs in public service, police officers have the most difficult.
Oh, you telling a lie.
They must make snap decisions.
Oh, see again. Let me get my self-control. Let me get my soul under control. My mind, will, emotions, imagination, and intellect under control right now. Again, we're looking at the problem, purpose, perspective, paradigm, and price as we look at these rotten, corrupt, deadbeat judges, attorneys, and the like, which includes police officers as well as a system that are in place. And police officers as public officials don't have the most dangerous jobs over here. They do not, from my perspective. And as we talk about problem, purpose, perspective, and paradigm and price, remember, we're looking at all these terms from different angles. We're flipping the words. And we're looking at them from every angle. We're looking at the how. of the problem, purpose, perspective, paradigm, and price. How, when, where, why, to what extent, who, which one, what kind, how many, how much. We're looking at all of that. So we're getting to see the judge's perspective by listening to what's coming out of her mouth. Her perspective, how she's viewing this. She's telling it to us. We can hear her.
Under tense, evolving, and ever-changing circumstances, they risk their lives every single day in public service. Officer Potter made a mistake that ended tragically. She never intended to hurt anyone. Her conduct cries out for a sentence significantly below the guidelines. Okay, thank you.
So we're talking about corrupt, rotten and corrupt judges, attorneys, officers, systems, and the like. Now, my perspective of the judge has already been made as I sit there and I listen to her. And I'm saying, let me hear what her perspective is. Okay. Her perspective is officers are the it all be all because they risk their lives more than everybody else on a daily basis over here in the United States of America. And that's not true. Hey, Evo May, how you doing? And Letha, I see you too. But stop really quick and make sure I am in. And I put it short on your name, Evo May. To sit there and to cry and to say you're not attempting to minimize what the family went through is a minimization of what the family went through, from my perspective. You just minimized an officer being licensed to kill. And she sat there and she sanctioned it. That's sanctioning the murder of Deontay. That's what she just did. Look at it from the officer's eyes. It was a mistake. No, it was not a mistake. It was on purpose because she intentionally had a gun in her hand, calling it a taser. That was on purpose. That was not a mistake. There's no possible way for an officer who's been in a field for any length of time to mistake a gun for a taser. Forget that. So my perspective on this judge, she's giving me, I don't care how soft-spoken she is, sugary sweet. Those who know how to the S, sugar the, you fill in the blanks. Those who want to talk with a soft-spoken tone, but what they say is lethal when you listen to them, could be real lethal versus someone who's more bold when they speak, like myself, can be assertive and authoritative when I speak. who voice and words, when you in the atmosphere with them, command authority, a little bit more authority. Yeah, then you get these ones who are serpies. They so soft when they talk, and what they say be just as vile as ever, and be lethal. Mm-hmm. And everybody just say, "Oh, they're so oh." Miss me with that dumb stuff. Again, when you have rotten judges, corrupt judges, who got a jacked up paradigm and set a jacked up paradigm, that's a pattern, that's a model, and justice don't get served. 24 months, 2 years, over 2 years. No, that's 2 years. That ain't no justice. That's not justice. 16 months in prison for murdering somebody intentionally. Again, over here in the United States of America, let me tell you what my perspective is. The police can get away with murder. They have immunity. They've been doing it for years. You want a license to kill somebody unjustly and be able to get away with it? Be on the field. Be on the police field, police force. And then you get some judges who sanction what you do, because they're not there to be unbiased. Oh no, they're not even there for justice. They're there on an agenda and with a very different purpose. Yeah. And it's a problem. And the price is lives. It costs lives. Lives. Other people's lives. They're no longer here to live. Yeah, they're dead. Yeah. Mm-hmm. Another price that's paid is pain. You're causing the family members to go through pain and trauma, distress, suffering. Emotional distress, mental distress, psychological distress. So when we're looking at these rotten judges, attorneys, police, systems, facets of the system and alike, think about it. Again, think about the word, think about the problem, purpose, perspective, paradigm, and price. How, what, when, where, to what extent, which ones, what kind, how many, how much. When you're looking at problems, perspective, think about all of that. If we're going to put it in perspective, we have to flip it and look at it from every angle. It's a problem for the judge to sit her behind up there and start crying. Not because he is dead, but because she had to sit there and sentence an officer. And the officer only got 24 months. Then she gets probation, considering, you know, she don't go to prison and get in any trouble. And I borrowed a word from my family members, one of my family members, and so let me use it. It is a problem when you get these judges and attorneys who go to universities not to obtain the juris doctorates, but they come out with these juris dumdricks. Okay, they go and they get these juris dumdricks degrees, and then they make themselves into the system. after obtaining a Juris Doctorate degree. And so let me define Juris Doctorate degree from my perspective. You're not competent. Not only incompetence, you don't have any integrity. You don't have any ethics about yourself. You don't have any good character. You shouldn't be presiding and practicing nothing. Presiding over anything or practicing anything in the United States of America that has to deal with justice. Let me move on to the next one. Move on to the next one. Let me do the share on this. See, because this is another one. Let me go here. And while we're getting ready to look at another example, Steve Greenberg, attorney Steve Greenberg, and I'm gonna call his name because I done said some stuff in some social media posts pertaining to his rottenness or him or what I feel about him as an attorney before. Ineffective counsel. You get ineffective counsel. Ineffective judges presiding over cases. It's a problem. Pull this up. Okay. Robert Sylvester Kelly. This is the example I'm concluding on tonight. Okay. Motions have been put in place for him. All right. And I said I was going to be revisiting this one. And as I revisit this one, I'm not going to look at today the parents, okay? I'm not going to look at the parenting style. And when I get to the parenting of the alleged victims, my perspective is probably going to be quite interesting. My bias will show through. My implicit bias will probably show through. And it's going to be quite interesting because I'm going to come from the perspective of having taught, of being a former educator. Okay. And so I'm going to have a perspective that may appear to be biased to some. And some may say, well, that's the implicit bias, subconsciously, what you're not aware of, showing through why she's talking about this when I get to the parents. However, my perspective, again, will come from one who taught students for years. And when you are in classroom with students and you work with children and teens, understand this. As a teacher, instructor, before I even had a child, I always understood that it was my responsibility to foster an environment, a healthy environment for growth and development, a safe environment, okay? To nurture, to cultivate, to produce such environments. To draw out of the student the best or the better part of them, the best of them, okay? The best of them, right? To paint a picture on the canvas of their imaginations, to see things from a different perspective, and to inspire them to be what they were created to be. to teach in such a manner that happened. So I'm gonna wait on those parents, because this Black History Month, let's flash back and we're gonna walk it up, and I'm gonna do the screen share. While I'm flashing back, let me go ahead and do the screen share. Do screen share. I'm just setting it up so you can understand. And again, this is not all of it. Do the screen share on this. I'm gonna have to probably put my glasses on. I should have. I had switched this up to a be chocolate. Changed the words to my little chocolate coloring, and then I said, okay, I'll revert it back to this. I should have stuck with the chocolate on this. So, okay. All right. All right. Remember, we're talking about rotten judges, systems, attorneys, and it could be a defense attorney. It can be a prosecutor. Doesn't matter. Police officers, facets of the system. Excuse me, that's right. We're looking at it different angles, different perspective, turning it around, different facets. So I'm going to wait on the parents before I address the parents, because flashback to a few years ago, during Black History Month, when there were a lot of content creators and it was all over social media, and they were saying, well, Robert Kelly and Jesse Smollett messed up Black History Month that year. This was some people's perspective, all right? And some people were saying this, and I didn't touch it. During Black History Month, I stuck true to just doing strict for that entire month of February. When I did my live streams on YouTube, I stayed strictly with Black history, Black excellence, and U.S. history. And when I did address this whole situation from this Me Too and Time's Up, or whatever they want to deem themselves and call themselves, interesting, my title was, and it's still up, the video, you can search it, was Mute These Trifling Parents. Mute these parents. So when I read the motions that was placed by Attorney Jennifer Bowen Jr. on Robert Sylvester Kelly's behalf, as it pertains to the parents of the alleged victims, it's going to be agile, broken down into pieces. Okay. Yeah, because I definitely had something to say to parents. I had something to say over 2 years ago when I came out, and I didn't even put his name in the title. I just said, no, mute these trifling parents. And again, it came from a perspective of understanding what a negligent parent is, what a negligent parent isn't, what a grossly negligent parent is, and what a grossly negligent parent isn't. And at the root of people growing up, minors being problematic, it's going to lead back to the parents and the foundation that the parents laid, or a parent. Could have been a parent missing in a home, could come from two-parent home, but it goes back to the parenting style. Now, having said that, let me get to this. Let me put my glasses on. Can everybody see this? Make sure y'all can see this. Oh, yeah. Let me look at it from the other device, because this may be a little bit blurry. All right. So for the last example tonight, when I'm talking about rotten and corrupt judges, attorneys, and remember, it could be a defense attorney or a prosecutor in all fields. Doesn't matter what form of law they practice. It can be a police officer. It can be a system put in place, and we know elected officials can be corrupt and fall into rotten and corrupt categories, okay? But let me make sure this isn't, okay, that's a little blurry looking there to me. This is why I should have kept it chocolate. All right, so another thing, I have this already zoomed in at 125, okay? For my own intent and purpose. Now, Attorney Jennifer Bonjean is a female attorney, defense attorney, that I consider to be a master swordswoman when it comes to the law. Okay? You can have people, let me give an example really quick. Okay, you got people who are summarized, you know, who can use the summarized swords. If you ever look at fencing and other parts of any type of people who specialize in using swords, if you watch any, whatever category it falls underneath, if you watch any of that, a master swordsman is able to use a double-edged sword. That means it cut both ways. Double-edged sword, we know, cut both ways. Okay, blade on each side. But a master swordsman can take what's not a double-edged sword and still use it like it is one. Now, when it comes to Attorney Bonjean, who I call the cleanup woman, based on the type of cases that she has taken, she's a master swordswoman when it comes to utilizing the law over here in the United States of America. Extremely skillful and crafty at what she does. Have to be to go in and get males who've been in prison for years out. You have to be. Okay? You have to know what you're doing. Okay, she's also presiding over Robert Sylvester Kelly case in Illinois. I mean, not presiding, but she's representing him in the state of Illinois in that trial now, too, as well as doing his motions, post motions from the New York. And I'm happy an attorney I consider to be a deadbeat attorney, Greenberg, is no longer on the case. Period. He's no longer on the case. So we know we need to watch out for deadbeat attorneys, because there's no possible way his client ever should have been in prison at all. He didn't have a record. I'll say it again. His client did not have a record. Not only did his client not have a record, he's a brand. His name is a brand. How do you allow your client's likeness and image to be utilized by a bunch of accusers with accusations, theories, and conspiracies that had not been proven? And let me make this plain. Jennifer Bonjean, through her motions, makes it very plain and clear that the government didn't have any evidence to substantiate their claims. That's in her motion. That's in this motion. That's in its motions. Okay, again, this motion right here, this particular motion was 65 pages. I do not have all 65 pages. On this, I only went through 14 pages. And then it's the other motion. Now, the latest update is, okay, she put the motion in, and then the judge did her response and said, you know, with she needed to submit her motion to have extra pages because the judge only allows so many pages, and attorney Jennifer Bomjean didn't let the judge know in advance that she would have 65 pages in a motion, and the judge only usually allows 25, so on and so forth, whatever. However, the judge, Jennifer Bomjean, did what she needed to do, and so now the pages that she submitted in the motion, post motion for R. Kelly stands. Again, that's what happens when you're a master swordswoman. My analogy I'm using when it comes to U.S. law. All right. So let's go here. I have my glasses on. Loosen this up, son. But I don't like to see it from that perspective. The thing about with my glasses is I'm not supposed to wear them when I am looking at any type of screens. Sometimes I just, and it, I guess. All right. So, all right. Introduction. N. Fitzgerald versus Chrysler Corporation 116F 3D, which means third edition, pages 225, 226, 227, 7 Circuit 1997. Judge, let me pull this closer to myself. Maybe I should zoom out of this because I need to be able to read this. All right, and when I zoom out, that looks a bit better to me. Then I can put my glasses on and read from there. Okay. So I'm in the introduction, first paragraph, still in the first sentence, and I should have slowed it down and said 1, 2, 3, ready, read. So if you want to read along at home, we can read this together. Okay. So Chief Judge Polisner cautioned that where the statute is broadly worded in order to prevent loopholes from being drilled by ingenious lawyers, there is a danger of it being applied to situation abruptly remote from the concerns of the statute framers. Such is the case here, where the government misused both the racketeer influenced and corrupt organization statute, which is RICO, and the Mann Act in a manner never previously conceived or carried out. And I would concur with attorney Bomjean right there. It is something that I have mentioned over here often. That how in the world do you go in with a lack of evidence and make a case that you based off some foolishness? By the way, let me just go here real quick. Let me go here real quick. Okay, I skipped when I left pages blank intentionally to give myself time to read between the pages when I was uploading this. Where did I want to get to? Let me go back. Please tell me I put in here what. Oh, all right. The jurors. The jurors. Let me blow this back up now. They shouldn't have been allowed. When you have jurors who watched the R. Kelly docuseries, they should have not been allowed They should have never been allowed to be jurors. We had that in here. Okay, with speculation going on before, but now it can be proven that the jurors up there, some of the jurors up there have watched the R. Kelly docuseries, and they should have never been a juror. Let me pull it back. Okay, with speculation before, a theory before, not a conspiracy, but a theory before, but now it can be proven. That's in its motion right here. She went back through that paperwork, and now that can be proven. So let's check that off while we're talking about corrupt judges, attorneys, and systems and the like. So hear me good. For people who've been out there, the media, for one, who assassinated his character, some other African-American people as well as other ethnic groups who assassinated his character, it was never based off facts. And I can only say this. It can never be said enough that when you are in these courts, you better make sure that you don't have corrupt people, rotten prosecutors, corrupt prosecutors, bringing these cases. And you better make sure, we need to make sure that we don't have rotten and corrupt judges presiding over cases. Because jurors in the motion, she went through it, checked off that they had seen the docuseries. Not only did some jurors watch the docuseries, that means they never should have been a juror because they were already swayed. Jurors admitting to, yeah, it would cause them. They already viewed him as in a negative manner and light. So you cannot have jurors sitting on a jury trial that are going to be biased. You're supposed to be non-biased and look at the facts. It's strictly the facts. And the judge gets no pass from me either, because if and you will find out also in this motion, the attorney Greenberg, Nicole, Tom Farinella, and then Leonard, the other ones, they didn't do their jobs, period. And so because Greenberg was out in the news media and he was the senior attorney on this case, he kept saying it, I'm a senior attorney, I'm a senior attorney, I'm a senior attorney, senior attorney. Deadbeat attorney is what I call him. Deadbeat, incompetent, and when it comes to this right here, and ineffective. I don't care about you being the senior attorney when your client is sitting in prison and they should have been at home, when the constitutional rights have been violated. And oh, she got that in here too. You got biased jurors sitting up there who should have never been allowed to be up there. They should have been struck. And then you have Nicole Becker, who was working for Osriel Cleary and R. Kelly, where Osriel was testifying against R. Kelly. That's a conflict of interest. Not only that, you moving over into ineffective counsel. She has that in here too, because that's what I was trying to figure out. During the Curcio hearing, the judge said to R. Kelly, well, Nicole had to stay on if you don't let her go, and da-da-da-da-da-da-da-da. You can't come back and say ineffective counsel. Well, Attorney Jennifer Bonjean said pump the brakes. Not so fast. Yes, he can. According to the Constitution, yes, he can. Uh-oh. But let me go right here. Uh-oh. That's the difference when you get a master swordswoman or master swordsman in law versus someone who is not skillful with cunning and crafty with the laws or interpreting them. And let me make this clear too. As some attorneys out there who know more about the law and how to interpret the law than a lot of these judges. Than some judges. Let me not say a lot. Than some of these judges. And that's just the reality of the situation. Because Jeffrey Feiger from my state be correcting judges all the time here and challenging their perspective and interpretation of the law based on the laws and prior cases. Again, let's get here. I'm jumping around. I didn't jump around. I'm gonna jump around in this. All right. Let me go back up to page 9 a little bit. The end of page 9. Is it? No, it's the end of page 4. All right. So let me go here. Before we get to the RICO, I want to let me read through this. Let me go back up to page 4. Okay, let me jump into this. I want to get right here. The government failed to prove, and I know I didn't finish reading through the introduction. That's going to lay out the order of the motion, okay? Chronological order of the motion. But I want to get to her fourth point. Government failed to prove the defendant's guilt of offense of racketeering count number 1. Remember, they found him guilty on all accounts, and she went through every account methodically. Not only methodically, agilely, she broke it down into pieces, went through it bit by bit. All right. Get this. Excuse me, everyone. I'm getting this dead skin off my lips. No, why during the winter time? Only during the winter time do I. Apologies, everyone. I have to sit up here and so much dead skin off of my lips. Only during the winter time. Summertime lips be smooth as silk. Anyway, okay, that's a side note. Let me get back on purpose. On focus. Okay, number 1, the government, and again, I'm jumping around. I'll probably jump back to the introduction, but this right here is going to lead into the jury questionnaire. Okay. So, first account, the court must acquit defendant of the offense of racketeering where the government failed to prove the defendant guilty beyond a reasonable doubt of each and every element of the offense. The government effectively swamped the jury with bad character evidence that was guaranteed to produce a guilty verdict. But it proves on the charge offenses were insufficient. It's proofs. That's evidence. What you got to submit to the court, proofs. That's why when people talk about, I got receipts, I said, no, I don't. Receipts can be altered, edited, modified, and things like that, and changed. I need the proofs. Run the proofs. Run the evidence. That hadn't been tampered with. Okay, run that. So, but the proofs on the charged offenses were insufficient as a matter of law, ignoring and distinctly economic legislative history of RICO statute. The government brought a RICO prosecution against defendant. not to remedy widespread criminal activity of an enterprise, but to punish one man whose alleged crime could no longer be prosecuted by state and local agencies. The government belated interest in prosecuting defendants' alleged victims does not justify applications of the RICO statute to the alleged private sexual conduct of the defendant and only the defendant, even if some of that conduct could have been timely prosecuted by local authorities long ago. Statutes of limitation, right? She's going for prior bad acts. What's called in law prior bad acts. Remember when this was happening, I said, you know, it was a prosecutor who got in trouble some years back for prosecutorial misconduct for piling on a defendant some years ago during this one case, prior bad acts. That's using everything they've done in their life and just coming in and bringing it before all the jurors. Well, that prosecutor was punished for prosecutorial misconduct. That's an ethics violation. Now, that's a prosecutor getting over into misconduct. These are some of the things that on this channel that was said before that I was questioning. And people tried to allude to the 2008 trial. And I said, no. Forensics won that case because the electronic evidence had been tampered with. So for this case, when they kept saying it's a bunch of videos, I said, I want to know about the authentication and the validation of any video that they think they got. If you got some ESI, bring it on, right? Because that is my field, right? Right. Digital forensics, computer forensics. Going in and what? Retrieving evidence, electronically stored information, interpreting electronic stored information, handling, maintaining electronically stored information in a way that's admissible to the court of law. So I had to learn some laws over here in the United States and learn some international law, right? So 2008, the digital forensics won that case because it had been tampered with, wasn't authentic, right? No authentication, no authenticity. You tampered with the data, the integrity of the electronically stored information was tampered with. It was altered. It was modified. It was edited. That's what won that case. In addition to those alleged witnesses, that alleged accuser of not showing up. Yeah. For this case right here, I kept saying, where's the evidence? Bring me something concrete that's going to substantiate the claim. I don't want to hear about he say, she said. Substantiate your claim and come with that proof and that evidence. That hasn't been altered, tampered with, modified, or deleted. Again, while we're talking about these corrupt judges and attorneys in the system and the like, again, we are looking at the problem, purpose, perspective, paradigm, and the price that's paid. You put this in perspective here. So let's put it in perspective. I'm still waiting for the electronically stored evidence that they said they had to show up. Now, see, people ran around with allegations, speculations, and conspiracies and theories, but that don't make the evidence and the show don't make it fact or truth. Now, again, I like to be science-driven and evidence-based. If I'm going to talk about a case, you're going to have to show me the forensics. I want the fingerprints. I want the biological forensics. I want the digital forensics. I want all the forensics. Don't sit up and tell me about documentation that has not been authenticated or validated. Again, but let's look at who brought tapes up and ran them to CNN. Michael Avenatti, who's going to have to serve out his own prison time for what? Fraud. For fraud. Not only fraud and money laundering, Michael Avenatti was never licensed to practice in the state of Illinois. He came out and said somebody gave him some tapes. And he took the tapes to CNN. He didn't take the tapes to the police. Excuse me, stop it, pump the brakes. The person who gave you some tapes or something that was on video, anything that had to deal with any form of digital or electronic should have what? Went through a chain of custody, should have what? Been what? Authenticated. In this field of digital forensics, what? Authentication is vital. Show that evidence hadn't been tampered with. What you need to what? Validate the information. And so when I'm gonna get to this next sentence, paragraph, excuse me. But before I go there, follow me here, because always I'm going somewhere. I'm painting a picture. So a problem. It was a problem from the start with that. The way this whole thing came about, it was problematic. You had that coming from Avenatti. And you had him say he ran that to CNN. And it was allegedly supposed to be involving underage minors, right? People kept saying, oh, it's pedophilia, it's pedophilia, it's pedophilia. Oh, it was raped, he raped. He didn't rape anybody. They never presented any information or evidence to substantiate a claim of him raping anyone. Let's be clear about that. The SI, electronically stored information, or the digital information or evidence that they were supposed to present. I wanted to know about the validation and the authenticity of that, because I clearly saw a chain of custody being broken when Michael Avenatti ran alleged evidence to CNN versus taking it to the police, FBI, whoever, whatever, right? So that was corrupt and foul from the start, rotten from the start, right? Corrupt and rotten from the start, right? And corrupt systems put in place to allow that to happen. Okay. Kim Fox, who gets no pass from me just because she's an African-American female. I expect for African-American females who get in positions of authority to do their job and to not be biased. That's what I expect. Okay. Period. I expect for them to go even harder in terms of justice and being ethical and walking in the utmost integrity. What you do when ain't nobody else around and nobody's watching, that's what I expect. Okay. We had her and Avenatti colluding together. Victim, and you didn't set up on the phone because they pulled some records for her too. They pulled them records from her office too. So y'all sitting on the phone having conversations, right? Who brought charges against R. Kelly in what? Chicago. Based on what grounds? Off a docuseries? her words from her mouth. I played it over here a couple of times. I played it back and over years ago when she first said it. Yeah. When she first said it. And the reason I was looking at Kim Fox is because of Kanika Jenkins' case, right? Right? Uh-huh. Yeah. She had just got elected. Yeah. Voted in. And I was like, okay, she's not doing anything or putting her weight behind this at all. You know what? So, you know, always viewing her as a what? District attorney, as the prosecutor, right? In Chicago. Came forth and said, victims, if you were a victim, after I watched the docuseries, if you were a victim, please come forth. We're talking about what? Rotten. We're talking about somebody being rotten now. Because if you had a case, you don't need nobody to come forth. You already got what you need. All right? Your evidence is on lock. You don't need to watch a docuseries to file charges against somebody when you're supposed to have your evidence on lock in advance. Period. Got up there and said, is there any victims? Please come forward. After watching a docuseries, which never should have been published anyway, because Greenberg should have done his job. Deadbeat attorneys, right? Tom Farinella, Nicole, and Leonard. I got them all in a deadbeat category because you allowed your client to sit in prison and allowed his image and his likeness and his person to be used. Yeah. While Greenberg is still out here attempting to defend himself. So what? We see a what? Paradigm, a pattern, a model that's set by what? Prosecutors. That's their paradigm, how they moving. And prosecutors and defense attorneys. What? Paradigm. We said we was going to look at the paradigm too, right? That's one of the words I put on there. Paradigm, a pattern, a model. And again, I kept saying, where's the evidence? Bring me some concrete evidence. I don't care about he said, she said, because he can lie and she can lie. Bring me something that can substantiate the claims. And people swooping down. There's a bunch of electronic evidence. It's a bunch of video. There's a bunch of electronic evidence. There's a bunch of digital evidence I have yet to show up. And when it does show up, it better be authenticated. And the data integrity better be intact. Now, oh, I just said that right there. I just said that right there. While we're talking about corruption. And I'm talking longer than I want to on that one point. I really am, but I don't care. It's been a minute, what, about 5 days since I went live. Let me move on. Let me move on. Let me get off my side notes and valid points and move back on and move on. And many people were attempting to debate my perspective or my post on YouTube when it came to this particular trial right here. And I kept saying, okay, you're saying this, but where's the evidence? I don't care about your speculations, your allegations, your conspiracy, and your theories. You better run me some evidence. And they said, oh, where a certificate showed up in court that he was married to Aaliyah, la, 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 la. Jennifer Bonjean went for that too. She went there for that too in this motion. The witnesses, she went there on all of them. Okay, you want to come up? Some of them got immunity from the government. You want to come up and do that? All right. All right. Okay. Now, again, we're still on the RICO. I'm on page 3. Next paragraph. Underneath RICO, first charge. Okay. I know I did my deviation, my pivot, my side notes. Now let me continue to read. I said we're still under the first charge, RICO, right? Racketeering. As a reminder, RICO's primary purpose was to combat organized crime by prosecuting the highly diversified acts of a single organized crime enterprise under a RICO's umbrella. The overarching goal of the statute was to curb the infiltration of legitimate business. And again, like I said, I intentionally left some pages blank to give myself, to space myself out some. Organizations by racketeers. And its statement of finding and purpose accompanying the RICO statute, Congress declared the following. Let me put my glasses on for this. Again, I should have left this in chocolate. All right. Apologies again for getting this dead skin off my lips. That only. All right. The Congress finds, number one, organized crimes in the United States is highly sophisticated, diversified, and widespread activity. And we're talking about the RICO here. That annually drains billions of dollars from America's economy by unlawful conduct and the illegal use of force, fraud, and corruption. Now, this is under RICO, okay? This is what the government was supposed to prove during this trial. That didn't happen. Now, number two, organized crime derives a major portion of its power through money obtained from such illegal endeavors and syndicated gambling, loan sharking, the theft and fencing of property, the importation and distribution of narcotics and dangerous drugs, and other forms of social exploitation. That's number two. Number three, this money and power are increasingly used to infiltrate and corrupt legitimate business and labor unions and to subvert and corrupt our democratic process. All right, let me move down some as I go to number four of the Congress interpretation of what RICO statute is. Number four, organized crime activities in the United States weaken the stability of the nation, economic systems, harm innocent investors, and competing organizations interfere with free competition, seriously burden interstate and foreign commerce, threaten the domestic security, and undermine the general welfare of the nation and its citizens. Number five, organized crime continues to grow because of defects in the evidence gathering process of law, inhibiting the development of legally admissible evidence necessary to bring criminal, other sanctions, or remedies to bear the unlawful activities of those engaged in organized crime, and because the sanctions and remedies available to the government are unnecessarily limited in scope and impact. Now I'm on the last few sentences. underneath the Congress intent, original meaning of RICO statute. It is the purpose of this act to seek the eradication of organized crime in the United States by strengthening the legal tools and the evidence gathering process, by establishing a new penal prohibitions, and by providing enhanced sanctions and new remedies to deal with the unlawful activities of those engaged in organized crime. Organized Crime Control Act of 1970, number 1 of publication 1, number 9, publication 1, number 9, and pages number 91 through 452. That's what that stands for. Collin versus State Chemical, MFG Company, 584 F. Then SP's supplementing pages 619 and page 621. Okay, and then she's citing the sources here. All right, EDPA 1984. Now, again, purpose, problem, perspective, paradigm, price. All right. When we're talking about corrupt judges, attorneys, law enforcement systems, aspects of the systems, and the like. And let me move down. And this is first charge, RICO. Admittedly, prosecutors have used RICO in a wide variety of circumstances under the statute. Liberal construction clause, HG Incorporated versus Northwestern Bell Telephone Corporation, 492 U.S., pages 229, page 248 through 249, 1989. The liberal construction clause, notwithstanding, the Supreme Court has acknowledged that the clause is not without limits. Veers versus Ernest and Young, Reeves versus Ernest and Young, 507 U.S., pages 170, page 183, 1993, as the court held that Reeves, the liberal construction clause, was not an invitation to apply RICO to new purposes that the Congress never intended. The government clearly exceeded those limits with this prosecution, as evidenced by its failure to prove the charge offense of racketeering. We already knew they weren't going to prove racketeering. No one man is an enterprise. Period. They weren't going to prove that from my perspective. All right. Next page. Court could not make a case. Okay. Court could not make cause challenges for defendant or do defense counsel's job for it, although it tried at points. Ooh, goodness. That's loaded right there. Jennifer Bojangles said, look, the court, y'all tried it. You tried it. Prosecutors, y'all tried it too. You tried it. You tried to do the defense counsel job. You tried it. Overreach, overstepping. She's saying y'all tried it. Woo. All right. Come on. This is why she's a skillful swordswoman. That's why she's in this category. All right. It was defense counsel's responsibility to conduct a meaningful voir dire, and that's the way it's pronounced. It's a a French word. Voir dire, French. Isn't that French? I'd have to ask my child. Okay, she speaks French. I ask her, but that's French to me. Anyway, particularly in this highly publicized case, to ensure the defendant's jury was fair and impartial, trial counsel failed in its duty. Nicole, Steve Greenberg, Tom, and Leonard. The four that had 2 years to deal with each and every witness and get every motion in the world in within those 2 years, you did not do your job. And Greenberg, again, Steve Greenberg stays on my deadbeat attorneys list. Since he's the senior attorney, and he wanted to keep saying, I'm a senior attorney, I'm a senior attorney, I'm a senior attorney. So what? With all that infighting with some junior attorneys, with his senior attorney having self. Oh, I said it. Again, over here, we know we have to watch out for defense attorneys, prosecutors, judges, systems, and the like. Period. Because everybody does not have your best interest at heart. We know that. These are things that we know. No, let's roll with it. Let's roll. Let's roll on. For people who don't understand what let's roll on means, from my Slangonomics dictionary, that means let's proceed and move on. Yeah. I'm still waiting for the evidence. I'm still waiting for some concrete, solid evidence. And when I said it was non-existent, people came all kind of, oh, they got it, or else he wouldn't have got convicted. They got it. Just because he got convicted does not mean that they had the evidence. It's a bunch of people sitting in prison convicted, and they didn't have the evidence. Or evidence was tampered with. Evidence for that could have cleared them were suppressed. All right, evidence was not existent. So you can't say just because jurors found a person guilty that, or they just had all the evidence in the world and you haven't seen anything. Again, and you haven't seen anything, and then you go online to non-credible sites and sources of information, and you think you have valid certificates that have not been authenticated or valid facets of information. And then you get people out here spinning narratives. Oh, the certificate, their marriage certificate is sealed. It's been publicly sealed forever. Oh, it was destroyed. First of all, marriages in the United States is public information, right along with divorces. So when people start running down that path, I'm thinking, stop with the dumb stuff. And what did my family member call when you have people who go to law school and get these Juris Dumbdrict degrees, not a Juris Doctorate, Juris Dumbdrict degrees, because you cannot competently stand there and defend anyone. You went and got a Juris Dumbdrict, not a Juris Doctorate. You're not competent, ineffective counsel. All right, let me move on. Let me go to the last sentence before I get into the example. Go back up. The court could not make clause challenges for the defendants or the defense counsel's job for it, although at points it tried at points. It was the defense counsel's responsibility to conduct meaningful voir dire, particularly in a highly publicized case, to ensure the defendant's jury was fair and impartial. Trial counsel failed its duty. For example, juror number 3 provided the following information in the questionnaire. And the judges should have struck the juror too. The judges should, the judge, because that's part of their job too. Not judges remove jurors all the time. Yes, they do. Yeah. All right. So while people were saying, the judge accepted Jennifer Bonjean's the additional pages, because she was trying to say you didn't meet this, I will need you to do yada 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 yada. I say she know what's up. The judge know what's up. Yeah, I don't think you want to stand there and go toe to toe with Jennifer Bonjean, Judge Ann Donnelly. You know what's up. Because the fact of the matter is, she could be doing your job. Period. And from my perspective, since I'm going to put a perspective on it, should be doing your job, because you shouldn't have never presided over this case, period. I wonder, was this the first high-profile case that Judge Ann Donnelly ever presided over? I'm wondering. Because from the onset of this, I said she was messing up all kind of ways for me, period. One is, you should have recused yourself. Should have recused yourself, because there was some conflict of interest that were clearly obvious to me. All right. Juror number 3 provided the following information in the questionnaire. Question number 29. The case for which you are summoned involved the defendant, Robert Sylvester Kelly, known as R. Kelly. Have you read or seen or heard anything about the case, alleged crimes, or people involved? This is the answer for juror number 3. I watched the documentary, but I forgot the name of it. The name of the documentary was Surviving R. Kelly. How did they forget the name of that? Right? Wasn't it Surviving R. Kelly? Wasn't that the name of it? I didn't watch the docuseries. I said I wasn't going to watch that mess. And that's exactly what I call it. And I still stand on that to this day. I'm not going to sit down and watch any mess. You better show me some police reports. You better show me some proofs. You better bring me some real evidence. I want the forensics. That means bring the fingerprints off everything, every document you bring in here, because I want to know every hand who touched it. And I also want your medical report. Okay? That's right. Bring me the science. I don't care about the gossip. Bring me the science. I need the scientific perspective on this. I need information from the scientific fields. Question number 30. Have you read, seen, or heard about Robert Kelly, also known as R. Kelly? Answer: yes, entertainer. I've heard that he's been sleeping with underage girls. Let me blow that up a little bit more than what is blown up right here. This is juror number 3 now. And again, we have yet to get into 65 pages. We're not even, excuse me, you all, scratching the surface on this stuff. When you get biased jurors up there, and you need that's usually automatic mistrial, retrial. leads to what? An acquittal, right? Excuse me. Let me turn my head. That's my sinuses. There you go. Guess my little sinus want to start doing whatever, but during the middle of a live stream, okay, they need to stop this. All right. Again, apologies, everyone. Go back to reading. I don't like fiddling around with my nose during a live stream. But my sinuses were doing whatever they decided to do. Again, I blew that up, and let me look at it from right here so I can make sure it is not going too far off screen. But I needed to, I deemed it necessary for me to blow that up. Okay. I know you are, Letha. Let me hit the refresh on this another device. See, because I need to refresh this. I need people to see this. I have to let the record show. People want to let the gossip flow, but I have to let the record show. Let me pull that back. People want to let the gossip flow, but I have to let the record show. Again, as we are talking about corrupt judges, rotten and corrupt judges, attorneys, systems, police, elected officials, and the like. Remember, purpose. We're talking about what's the purpose, the problem, perspective, paradigms, and prices. Remember those 5 points. Problem, purpose, perspective, paradigm, price. So as you're listening to this, as you're listening to me read this, think about it. Problem, purpose, perspective, paradigm, price. Problem, purpose, perspective, paradigm, price. Problem, purpose, perspective, paradigm, and price. That's the cost. What is it costing? Paradigm, models or patterns that set perspective. That's the way a person views. The purpose, the intent behind the thing. The problem, what's the issue? What's the issue? So, question number 30. They clearly said, I heard he had been sleeping with underage girl. Your butt shouldn't have been on there. Number one witness should have been struck because what? You watched the docuseries, period. You weren't going to be unbiased. You were going to be, you were going to be biased, impartial, flat out, coming out the gate. Question number 30. Have you watched or heard any interviews of Robert Kelly on TV shows featuring him or any special or documentaries about him? Answer, yes. Judge could have dismissed this person herself too. Let me pull it back. The court could have dismissed this person too. The judge, she could have dismissed this person too. Okay, defense counsel, they didn't strike it. She just letting it flow through like this. You a judge? You a judge? What is her pattern? What's her model? What's the model? What's the model that's in place? What type of pattern is she creating? Again, in the title, I have rotten and corrupt. Now, people probably say it doesn't quite, you can't say that this is rotten and this is corrupt. Yes, it is. Yes, it is. Yes, it is. Yes, it is. When you read through them transcripts, when I was posting on my community wall, people reading through the transcript, like infamous Sylvia, which is the first one who came right out the gate, while she was down there doing a trial, attending a trial. R. Kelly trial. She was the first one that was attending the trial that started reading the transcripts, and people had so much to say about her reading transcripts. And I said, no, read the transcripts, because the news media is not going to tell the truth. They're not telling us anything. They're not telling us what's going on in this case. They're not telling us anything. They just coming out bashing, slandering his name, making him out to be a villain. They're going off old news or old theories and what they thought they had, but they don't produce the evidence. No journalistic integrity to research a thing out, to investigate. So I said, yes, if you don't say this information, my perspective on that is, if she didn't read the information verbatim, we were not going to know. Those of us who were interested in justice and interested in knowing were never going to know this information. We were not going to know it. Yes, it was other people in the courtroom taking notes, and they were going note for note. They were also informing us. But at the same time, I said, no, we need all the information. We need all of it. All hands on deck. All hands on deck who are there to inform us with integrity of what's going on. Not the ones who were there to continue on with the spin, the deflection, and their own biased perspective on him. No, I wanted the proofs. I wanted to know how these judges how this judge was going to move in this case, what the jurors were doing, what's going on up in here, the transcripts. She sat there and she read them. She had other readers on there. They sat there and they read. And I wanted to know, why would people have an issue with that? Why would you have an issue with information getting out? Why would you want to conceal information? For what? What, you don't think the public should be informed? For those who was like, oh, she reading a verbatim. Okay. Assuming that the clerk wrote verbatim, was typing verbatim what was being said, because that's their job to do. No, by all means, do inform us. Yeah, I listened to the other people's notes, but I wanted to see the record that was being preserved. Show me the record that will be made public, that will be preserved, so I can read through it. That's a transcript. Show me that. Now, yeah. Now, having said that, let me move on. Question number 31. I don't even need to put this on, because I got this blown up so big now I can take these off. Have you watched or heard, and I already went through that one. Let me go to question number 31, the other. What are your general expressions? What were your general expressions? Okay. Under question 31. I saw a documentary about him and his legal troubles. I don't know the full story, so I have no feelings and remain impartial. No, you're not. Because you said up there before, you had heard he was sleeping with an underage girl. You had already watched the docuseries. This person should have not been a juror, period. We're going to get to the juror that was out there getting Gloria, Aldridge autograph. That juror was brought up in this motion too. Because Gloria was representing a client. Who? Faith Rogers, her client? Yeah. And the juror wanted Gloria autograph. That said everything to me. About that particular juror. They shouldn't have been up there either. Question 91. Do you know anything about Me Too movement? Yes, it's a movement that seeks justice for rape victims 25 to 30 years after the fact. But this juror was allowed to stay up there. You know all this. First of all, no juror should have been up there that watched the docuseries on Mute R. Kelly or Surviving R. Kelly, because pictures have already been painted on the canvas of your imagination. Why would anyone expect for them to be impartial and non-biased? What? Images and pictures are worth what? 1,000 words, and they what? Set up and watch a bunch of images and pictures as it what? Related to R. Kelly. And then had the audacity to come up there, and you expected for them to logically look at evidence and rationally render an impartial verdict based on evidence. No, they weren't going to do so. All right. Trial counsel did not ask the court to question the juror further about his responses to these questions, and it was a him, or to determine whether the juror could truly serve as impartial and unbiased juror in light of having seen the salacious and highly presidential docuseries. Not a single question was asked of the juror about his impressions of the documentary, nor did counsel ask the court to inquire about what information he learned about defendants' prior legal issues or his reputation for sleeping with underage girls. And that's what that juror said. He heard he had slept with underage girls. You know, he heard. Okay, you heard. He didn't see it, but he heard it. So that was already in his mind, on his imagination. It was in his conscious and subconscious. It's there. Right? Psychologically, it's there. Subconscious, conscious. Subconscious, conscious. Subconscious, conscious. Psychology, right? Subconscious, conscious. Yeah. Frankly, anyone who had seen the docuseries should have been automatically removed for cause. Let me reread that. Frankly, anyone who had seen the docuseries should have automatically been removed for cause. And that's right. Because I would have got your backside up off there, because you're going to be biased. You already have a perspective. All right? Again, let's think about it as we read through this. Corrupt, rotten and corrupt judges, attorneys, and the like. Problem, purpose, perspective, paradigm, and price. Let's think about it again. Problem, purpose, perspective, paradigm, and price. Problem, purpose, perspective, paradigm, and price, while we are talking about this. Juror number 4. Let's go to that one. And again, remember, 65 pages plus submitted by attorney Bonjean in this motion, post-trial motion. All right. Again, she agilely went through each account and broke it down, as well as broke down the witnesses. And She said, we're no evidence, insufficient evidence. She said insufficient evidence. I said, where is the evidence? Why is this even here? What footage? And if you got it, has it been authenticated? Let me talk about the validity of the data integrity. Has it been preserved? Let me talk about a chain of custody. Where did it come from? All right. So let me go back up. Juror number 4. Okay, juror number 4 revealed in the questionnaire. Now, let me scroll down a couple pages, right? So I even heard some attorneys' perspectives on this that I just didn't agree with. And like I said, I challenge you too. I don't care if you went and got Juris Doctor's degree and licensed to practice law, because some of you all went and got Juris Dumdrix degrees. You shouldn't be practicing anything because you ain't worth the salt you savor. Period. All right. Engaged and must be alleged to be proved separately. However, there must be a nexus between the enterprise and again, we're under the racketeering. So we're jumping back to, again, there must be a nexus between enterprise and racketeering activity that's being conducted. United States versus in Decato, and then so on and so forth, 1984, Okay, furthermore, the RICO enterprise must have an insurmountable structure separate and distinct from the pattern of racketeering activities. Turquette 452 U.S. at 583. So remember, we're still under racketeering. Why did I okay, again, it goes back into juror number 4. Questions being about R. Kelly, perspective on him, views somewhat negative. They should have been struck for cause. Question, why do you feel that way? The allegations related is that he was sleeping with underage minors. Okay, should have been struck for cause. Another juror who should have been out for cause. Okay, did I cut this? Yeah, I cut some. Okay, I see what happened here. Some pages I was leaving blank intentionally, and some of this, when I only took the pages that I wanted to share, I left out. So I'll have to go back later on and add those back in so it makes sense. All right, but we're still under RICO. First charge, okay. There has to be a nexus. Okay, I read that part. Finally, for again, she threw in there those jurors. She's saying ineffective counsel. They should have done their job, got these people out, these jurors off trial for cause. Clearly, they were going to be biased. They were partial. Show favoritism towards the victims, alleged victims, versus information or the evidence that was being presented. Finally, for 1962 purposes, the person charged with RICO violation and the alleged enterprise must be separate and distinct from one another. This requirement flows from the statutory mandate that a person who engaged in a pattern of racketeering activity must be employed by or associated with the enterprise. And she said, Sandwood, she gives the case here 385 F, third edition, pages 159, so on and so forth. She's giving the information for that. Rivers Chappell, she's naming just the various cases to substantiate her claim and why she's saying that. So she refers back to prior cases. All right, prior cases and previous trials. So she has it all in here. Burnett versus U.S. and Trust of New York, Barron versus Boatman, First National of Oklahoma. So she's going through and she's listing the various cases again, and that's what any good attorney will do, period. Or every attorney should be doing. An entity cannot simultaneously be the enterprise and the person who conducts its affairs. Permitting that would be tantamount to permitting an entity to associate with itself. Okay, Burnett, she goes right back into the cases where this was already established. An entity cannot simultaneously be the enterprise. Like, again, I said, how is R. Kelly the enterprise alone? Makes no sense. So how did they get a RICO conviction? How did they get that charge? How did they get any other charges? Well, if you got some biased jurors who should have been struck for cause, who were partial, it would make perfect sense. B, common purpose. In its third superseding indictment, the government alleged that the defendant, his employees, managers, bodyguards, drivers, personal assistants, runners, so on and so forth, and other members of his entourage constituted the enterprise for RICO purposes. Okay, and that is, the government did say that because that's who they was bringing in there, testify. All right. According to the government, the purpose of the enterprise was to promote defendant's music and his brand. That's not illegal. That's not affecting commerce. Remember what the Congress said the statute of RICO was. That's not impacting our democratic process over here in the United States, promoting his music and his brand. Which is what they should have been doing if he hired them to do such. As an artist, a composer, producer, and musician. Number 2, recruit women and girls to engage in illegal sexual activity with the defendant. Now, this is what the government, this is what they came up with. Produce pornography, including child pornography. No proof of that at all. None. The government did not allege that the enterprise Mm-hmm. Going down. Wait a minute. A 6. Make sure I got 7. Okay, yeah. Although the court could have this goes back into that. This is why I shouldn't have left pages off. Okay, that goes back into the juror. Juror number 7. We got juror number 4, juror number 9, juror number 7. Just a bunch of jurors who were being biased. But let me get back to juror number 8. All the jurors. She went through juror by juror. Juror number 8, juror number 11. She went through them. Okay, back to the ineffective counsel trial. Gail King, your name was up in here too for that interview you did, because you had jurors sitting up there watching that. Okay, so going back, the intelligent exercise challenged by counsel, United States versus Beaumont. She goes back to into that case. Defendant received ineffective counsel assistance from where his trial counsel failed to conduct any meaningful voir dire of prospective jurors. And so she went through all of the jurors. And she goes back into surviving R. Kelly being biased. People being part, believing in Me Too's and all of that. The juror that asked for Gloria Allred's autograph. When you go to ineffective jurors, dumb Rick attorneys. All right, then we put back up to where I left off at, because she goes through, and again, like I said, she lays out juror by juror. She goes through the jurors, she drops them in there, every juror, when she hits this and that, and saying, okay, ineffective counsel, and she's saying, okay, RICO. When she hits the RICO, she goes through and she drops in what witnesses fell underneath RICO and why, and the evidence that was not presented, that should have been presented. Okay, so going from there, bypassing every juror who should have been struck for cause. And she listed every last one of them and the reason why, with the questionnaires, with how they answered the question. Okay. Understanding the defendant was a sexual predator because the defendant cannot possibly prove a likelihood of success if his case was heard by a fair and impartial jury. Prejudice must be presumed. Trial counsel abdicated all responsibilities to conduct meaningful voir dire, which resulted in the jurors that were largely unqualified to serve, and they were. The United States Supreme Court has recognized that in certain Sixth Amendment contexts, prejudice is presumed. Actual or constructive denial of assistance of counsel altogether is legally presumed to result in prejudice. That's that ineffective counsel. Also in there, she throws in Nicole Becker from Michigan, falls on any effective counsel too, because remember, she was representing R. Kelly and Azriel Clary, where Azriel is the government witness. She had attorney and client privileges with both of them. How can you do that? And so in a cursio hearing, that's when the judge was saying, well, if she stays on, you cannot later come back and claim ineffective counsel. And that's when Bonjean in this motion put pump the brakes, judge. Okay, that's where you, and you know, she didn't say this, but you can read through here. And my interpretation and perspective is she's saying, hold on, pump the brakes. This is where you're not interpreting the law correct. Because the Constitution says, regardless, if this happens, it's automatic. It goes under this. And you cannot come back and tell a person they can't file for ineffective counsel based off Constitution. You cannot do that because the Constitution states it this way, emphatically. Okay. And why did I? Okay, I'm gonna have to pull that one section back up later because I want to finish reading through there. But like I said, this is what happened when I set up and was like, okay, I'll leave these pages out. I should have just left all the pages in and just jumped around like I normally do. But me, what did I decide to do? Oh, I'll just upload the ones that I want and move them here and move them there. And now I'm standing up here like, Okay, so she makes clear that the Sixth Amendment says no. This is not what we're doing. Okay, these jurors gonna automatically be prejudiced. Okay, all right, that was her first point, right? Under RICO, but I have to get the rest of the RICO in there, and I will do such because we're talking about what? What are we talking about? Rotten and corrupt judges, attorneys, lawyers, because attorneys will lie, systems or facet of the systems and the like. The defendant, number two, the defendant is entitled to a new trial where one of his trial attorneys labored under a disabling conflict of interest, and I said it was as a result of her simultaneously representation of the defendant and the government star witness, Jane, that was imputed to the entire defense team. And Jane, why they sitting up here talking about some Jane? I'm not getting ready to sit up and call him Jane, and your name is Azriel, and you've been in a docuseries. I agree with Deborah O'Canic on that when he said he did not agree with them being called Jane Does and John Does, and they had already been in a docuseries. What was the purpose of naming them Jane Does and John Does, and people had already knew who they were? Extremely disingenuous on the prosecutor's part. Okay, put up some of that in my eyes. Okay, excuse me, everybody. I felt like I had some dirt in my eyes or something. So, put some little drops in there to flush out whatever that feeling is. And I do. I had a little piece of fuzz in that eye. What is this? A particle? Why I got a particle? Must have got it from I was outside taking out stuff and moving around. All right. So get these particles out my eyes. All right, yeah. So excuse me, everybody. Yeah, a little particle or something was in my eye. Flush that right on up out of there. All right. This right here speaks to Nicole. She was the only female attorney on the case. So for those who were following, this is for her. All right. And she goes back to the Sixth Amendment again. What the judge said in a Curcio hearing that could not be used. Attorney General for Bonjean begs to differ. And again, she's been practicing law for years, and she's a skillful master swordswoman with the law. So, and interpreting the law as it should be interpreted. All right. The defendant is entitled to a new trial where he was denied his Sixth Amendment constitutional guarantee of conflict-free counsel. Mere weeks before the commencement of trial, it was discovered that one of the defendant's attorney, Ms. Becker, may be suffering from a conflict of interest because of her prior representation of the government's key witness, Jane Osriel Cleary. Okay. I'm going to call her name. I'm not getting ready to sit up here sugarcoat and play these games like this, especially when you had jurors sitting up there who didn't see the docuseries. So they knew who these women were when they got to court, as well as the man who participated in the docuseries. We're not going to play these dumb games. And again, I concurred 100% with Deborah O'Canick when he said he did not agree with them calling them all Jane Does and Don Does, and the docuseries had been out there for years. It made absolutely no sense. Again, he came on the last few weeks. He did not have a 2 years and a half to sit on this information like the senior attorney, Deadbeat Greens, from my perspective, Steve Greenberg did, as well as the others, Nicole, Tom, and Leonard. He didn't have that time. He only had 4 weeks, him and Kevin Scholar, really 4 weeks to look over this information and get some type of evidence. So no. So, and the judge said if Nicole was going to stand on during the Curcio hearing, well then he couldn't come back and claim ineffective counsel, and asked him if he understood that if she stayed on, he couldn't use this. Well, Jennifer Bonjean said, you pump your brakes on that. You can pump your brakes on what you sit up in there and told the defendant. And this is the pump and brake section right here. Let me start over. Defendant is entitled to a new trial where he was denied his Sixth Amendment constitutional guarantee of conflict-free counsel. Mere weeks before the commencement of trial, it was discovered that one of the defendant's attorneys, Ms. Becker, may be suffering from a conflict of interest because of her prior representation of the government's key witness, Jane. Consistent with its obligations, the court conducted a Curcio hearing and concluded that Ms. Becker had entered into an attorney-client relationship with Jane while she was representing the defendant, which is R. Kelly, and Jane is Osriel. Although this conflict was an unwaivable conflict, because the judge in the Curcio hearing gonna tell him, well, then he waives. Let me blow this. Oh, I got it at 150 already. We zoom down on this. So, why the judge tried it. Again, we We need to watch who. We need to watch out for these judges. This is why I have in the title what I have in the title. Rotten and corrupt judges. Rotten. You rotten. That means if you rotten, the aura that you're giving off stinks. It smells. The aura of your character. It stinks. It smells. The aura of your integrity smells. The aura of your ethics stinks. In terms of you fulfilling your legal obligation as a one who is supposed to uphold the law in court. Yeah. And the cursor hearing, the judge said that he would waive his rights to come back and later claim ineffective counsel, and asked him if he understood. And he said, yeah, he understood, but attorney Bonjean is saying, not so fast, judge. It's unwaivable, period, according to the Sixth Amendment. So again, I'll go back to the point that I thought the judge should have recused herself from the start. Sitting up here playing games with these people, playing with people's lives, asking them some dumb stuff like that. I would have got the judge a long time ago, though, on some other stuff. And would have had her hemmed up, being reviewed, under review, so she couldn't preside over this case. Because it was some things that created a conflict of interest right off the bat with her even presiding over this case, this particular case. I mentioned those things in videos when it was coming down to this. I said, no. This one, I would already have her under review. I sure would have. I already know I would have filed on her. Long time ago. To get her removed off the case, and would have made my warrant and substantiated my claim. This is why I feel she should not preside over the case, and I want a new judge. That's the way I would have done her. And it would have been based all off her Me Too involvement and all the other things she had going on. Well, no, she don't need to be here. Not for this one. Go send her off to another case. All right? Not this one. So let me read that again. Now that I've strolled down some. Consistent with its obligations, the court conducted a cursory hearing and concluded that Ms. Becker had entered into an attorney-client relationship with Jane Azriel, that's you, while she was representing the defendant. Although this conflict was an unwaivable conflict, the court permitted defendant to waive it because defendant was denied conflict-free counsel by an attorney who likely possessed information that could have been used to discredit Jane's testimony, but was unable to utilize the information without revealing the attorney-client communications. Defendant was prejudiced by this conflict. Unwaivable conflict. Although the conflict was an unwaivable conflict, the court permitted the defendant to waive it. Again, better watch these judges. When our people end up in prison. And it's the fact to me that we get people in places like this that are rotten and corrupt, that could be rotten and corrupt, it equals and averages out to zero justice for the defendant or for the person that's being accused. Not only zero justice for them, zero justice for the person that's on the opposite side lying. Because they don't want to go to prison. The prosecutors come to them and say, if you don't take this plea deal, or if you don't take the plea, we're going to sit down and charge you with your crimes. But if you come and testify for us, you'll be immune from serving out your time for this, this, and this. Get up out of here. And I'll say it again, I'm not even scratching the surface on the motion that she put in. The Sixth Amendment mandates that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. U.S. Constitution Amendment number 6. This right to counsel includes a criminal's defendant's right to be represented by counsel of his choice. And then she gives the cases name for versus acted, and then citing Wheat versus United States. She lists the cases there, as well as the years, like she's been doing systematically throughout her motions. However, this qualified right is supported by, among other things, the Sixth Amendment right to effective assistance of counsel. A defendant's Sixth Amendment right to effective assistance of counsel includes the right to representation by conflict-free counsel. United States versus Swartz. That's why I said the judge tried it. A per se conflict of interest exists. Number 1, where the attorney was not licensed to practice law because he failed to satisfy the substantive requirements of admission to the bar. And she put he, but me, it means he or she. Number 2, where the attorney was implicated in the defendant's crime. United States versus the other person. And then, let me go down. Per se, the rule applies when an attorney is implicated in other crimes of his or her client sense. In that event, the attorney cannot be free from fear that a vigorous defense should lead to the prosecutors or the trial judge to discover evidence of the attorney's own wrongdoing. Okay, and she's given an example of that. An attorney has an actual, as opposed to potential, conflict of interest when, during the course of representation, the attorney and the defendant's interests diverge with respect to the material factual of legal issue or course of action, while the defendant is generally required to demonstrate prejudice to prevail on a claim of ineffective assistance of counsel. This is not so when counsel is burdened by an actual conflict of interest. Prejudice is presumed under certain circumstances, and that's where she got them at right there. The judge, too, when she sat up there and said, if she stays on, then you can't come back and say ineffective counsel. No, she's going to come. She's a skillful swordswoman when it comes to the law. So she's going to come back right at you with the law in prior cases. I don't know. I was trying to figure out what the judge was doing my own stuff, but I already said what I said about the judge. I would have had her removed from presiding over the case. I would have had her held up in under review for some other stuff. I already said that. And people was running around talking about, well, you're not an attorney. I said, well, excuse me, I don't have to be an attorney to be able to read and comprehend and interpret. Okay, some people don't always accurately interpret things, but this right here is reading comprehension. And if you don't understand it, you get a dictionary, encyclopedia, and you look it up. And furthermore, for those people who were saying that, I was like, excuse me, my degrees did require that I learn some law, international law, as well as some U.S. law. So you don't want to go there. You're not getting a degree in digital forensics and not learning U.S. law as well as international law, learning some of the laws as it pertains to your field. That is not happening. No. So right there. I said the judge tried it. When she sat there in that curse, you're hearing with that foolishness. She don't get a pass. Said that from the beginning. No, not giving out passes when it's supposed to be about justice. Just not doing it. No passes given. Not when it comes to justice. Let me say it again. No passes given when it comes to justice. Shucks. In the case at the bar, defendant is entitled to a new trial where his attorney labored under per se and or actual conflict of interest that could not be weighed at the cursive hearing held on and why did I go back into why did I cut that off like that? Okay, I did not include that in this. Oh, okay. I went right back into her laying out her claim. And saying why each charge was not proven. Okay. Racketeering Act 2, sexual exploitation of a child. The government did not prove. They failed to prove that. She went through everything he was charged guilty with. Guilty on all accounts. She went through each and every last one of them. But I wanted to emphatically go through what the jurors were doing, who should have been struck for cause, what the attorneys were doing, ineffective counsel, what the judge was doing by telling him to his face that, oh, you can't come back and claim ineffective counsel if you don't blah, 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 blah. If she stays on this case, you do know that you're waiving your rights to that. And then you go through the Sixth Amendment and you get it interpreted and you list other cases and incidents where there are exceptions to the rules per se. Again, this was my last example. And apologies, you all, for not normally, for just trying to go through and not uploading the document in its entirety and skipping around the entire document like I normally do. Again, I just want to hit key pages, and I'm leaving out some of the pages I wanted to hit. So let me stop that. All right. So as we conclude tonight, and it's 12:30. Okay. Let me say this. When it comes to these judges, attorneys, systems, facet of the systems, police, and the like, we think about the problem, we think about the purpose, we think about perspective, we think about paradigm, and we think about price being paid. Okay, yeah, right? Excuse me, everyone. Get this hair off my face now. This is enough for this. Yeah. All right. Then up off my face, like so. And then, whoop, I'm waving my hair the wrong direction. We need to think about all of that, and we need to stay actively engaged, right? Excuse me. I guess I could have stopped the video instead of ducking down, but I'm gonna do that. In each example is more than enough information given from the start of my Arbery, and then we went to the officers, the 10 officers who have been put on administrative leave because of the gentleman who ended up dead who was in their custody. Okay. And then from there we went to Kim Porter, right? Officer Taser, and the way the judge behaved there, right? Soft-spoken, very soft-spoken, and, you know, just syrupy, sweet, sugary, but said some things that were vile when you really pay attention to what was going on. Did display some behavior that was biased and vile when you think about the problem, purpose, perspective, paradigm, and price that was paid. Okay, person, parents there who was shot by an officer, and then she says it was a mistake. Trained officer on the force for over what, 26 years, and you mean to tell me you shouldn't know a difference between a gun and a taser? Yeah, miss me with that dumb stuff, right? She sat there and do not no, which equals zero justice. Okay, zero justice, zero. When you have people like this presiding over cases and litigating cases, it's zero. What form of justice is going to be acquired and accomplished on any behalf that would be advantageous and beneficial to the clients, to people, to U.S. citizens? Zero. And then you get in the final one, R. Kelly, and I'm again, I'll revisit that and bring up the documents again. What do you get? Zero. 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 Then you get attorneys, Jennifer Bonjean, which I called her the cleanup woman. If you follow her cases, again, Innocence Project and her history of just going through taking cases to get wrongfully convicted African American men out of prison. She has a history, a track record of that. When you get a skillful attorney like that, that's skillful in law and interpreting the law, coming behind judges and others, you see, you can compare and contrast. You get to see. She laid it out in all of those, but she goes through agilely, bit by bit, part by part, and lay it out. When you get a judge sitting up there telling someone in a custodial hearing, in the final example, well, you waive your right to come back and claim ineffective counsel because you have an ineffective counsel on counsel that has created a conflict of interest. And she asked him, did he understand? He said yes. And then he said he understood if Nicole stood on, it would waive whatever. And then you get an attorney who come back and say, no, let me give you the law and let me give you cases. That was never the case, number one. Never, ever the case. Period. And that speaks to the judge being a little bit rotten to me. That's a little rotten. Yeah, that's a little rotten. Right? Miscarriage of justice. Especially extremely rotten to me because Robert Sylvester Kelly has a disability. All right. Dyslexia is one of his in terms of, and then in terms of reading. So what he has to rely on other people to correctly read to him what's being said because they see words in a different light, right? Okay. Not only that, some other disabilities that he has. No, that was rotten of the judge to do. Very rotten. That's rotten. That's rotten. May not fall under corrupt category, could fall under there, but that's rotten. All right. So again, if you would, when you go back and you listen to the videos that were shown, and when I got down to the other one, again, I had to get my soul under control because the judge was sitting up here and she was on one when she started doing all that crying and was saying some stuff. I got it under control. I should have played it back for people to hear it in its entirety without me talking through it. And then said what I was going to say. I want you to think about problem, purpose, perspective, paradigms, and prices. Okay. In terms of rotten and corrupt judges, attorneys, judges, attorneys, police, elected officials, and the like. Think about it. Think about the how, who, what, when, where, to what extent about the purpose, what extent is the problem, what extent is, how, when, where, how did it happen, to what extent, which ones, who's involved. Think about all of that. Think about it for each different point, for problem, purpose, perspective, paradigm, price. Think about it. Just think about it. How did you, as a judge, sit your behind up in the cursio here and telling a U.S. citizen that if this happens, well, then that happens, and then that happened, and you didn't factor in the other facet of prior cases when you set your butt there and said that? How? Oh, I've been on here for over 3 hours all by myself up here speaking. However, I did teach for years, and that was 8 hours of straight talking and teaching. So, well, you got your breaks, but as I conclude, think about it. Think about it. And the fact that when you get rotten and corrupt judges, it equals zero justice. Think about that. Now, with that being having said, thank you all so much who stuck this out and did this live stream. You all have a pleasant evening and a pleasant night. I'll see you later on this morning because it is morning my time, and it is Black History Month. And remember to support Black businesses. And the reason I'm doing my earrings like that is because, again, like I said, it was created by the person I call one of my designers. I've had them on before, but I didn't buy this together as a set, although it looks like it was bought as a set. Customized, Black business, Black excellence. Support that, and remember, a few years back when they said R. Kelly and Jussie Smollett messed up Black history because of all of these things that came about, I said, no, it was people perspective, the way that they were looking at it. They didn't even wait for the evidence. They just assumed that it was there. And they went contingent based off of the theories and allegations that were allegation is not a fact. An allegation is not a fact. A conspiracy is not a fact. A theory is not a fact. A theory should prove a fact, can prove to be factual. Speculation is not a fact. Evidence that has not been authenticated, when it's digital evidence, we need to prove it wasn't tampered with first, right? Wasn't edited, altered, modified, delete. We need to improve the data integrity is intact, right? He say, she said is not fact, because people can lie. So let's think about it. They didn't mess up Black history that year. It was the spin and people perspective a few years back that messed up Black history. Because when they were out there talking about it, they should have been telling a different story. And the story they should have been telling is how, from the inception of the United States, historically, when it comes to African-American males and females, but males, you see it often, they have always been made out to be a villain. And it has been guilty in the court of public opinion before the trial could even happen. Yeah. You all have a pleasant evening and a pleasant night. Thanks so much for streaming, everybody. Again, happy Black History Month. Remember to support Black businesses, not during the month of Black History only, but 24/7 all throughout the year. Bye-bye, everybody. Remember, purpose, perspective, problem, paradigm, and price.